Please, Your Lordship, on behalf of Mr. S. Dev, I beg to mention item number 8 for respondent 3 and 4. I humbly pray that let this matter be taken up after 2 weeks.
On pre-meet by respondent 3 and 4, not objected to by petitioner. List this matter up to 2 weeks.
In connection to hearing number 11, 12 and 13, those anticipatory bail where the matrimonial matter has been settled, I beg to move the 482 application today, for quashing of the proceedings. Unlisted, I'm filing it this morning.
Then let it come in due course.
Due course,
You have filed the compromise deed.
Yes, in the anticipatory bail also I have filed
No. In the anticipatory bail application.
Yes,
it's there on record.
On record today. Otherwise,
so what we have to deal first with those applications.
Yes, my lord. If your lordship pleases, then your lordship may dispose of those anticipatory bail. This will come in due course.
Then we will dispose it as a withdrawal.
Not withdrawal, my lord, in factuals, because I will not be in a position to withdraw unless.
In factuals in what sense? That you have not been arrested so far.
No, but if the proceedings are quashed, my lord, anticipatory bail becomes factuals.
Oh, that will come later. That will come later.
Yes, my lord. So, my lord, we'll argue the anticipatory bail on the basis of the.
That become academic now.
Yes, my lord, but yet, my lord, I will not be in a position to withdraw, my lord, unless and until the.
So, what is the situation at the ground?
Situation is, it has been settled. The locker in Bangalore has been opened. The belongings have been handed over. Certain items have been handed over. The mutual divorce has been filed, my lord, day before yesterday. 50% of the amount of 85 lakhs has been handed over. After 2 weeks, my lord, the divorce petition is again coming up. We'll be making the final payment and then it will be disposed.
So what we can do is this.
Yes.
This court can record this settlement made.
Yes.
Since it has already been brought on record.
Yes.
That will be taken into account, and the issue will be disposed of as not pressed.
My lord.
It would not be,
yes.
dismissal.
Yes. On merits, but no, I'm not withdrawing. On merits. Let it come up, my lord. In the meantime, this will come in due course, my lord.
Yeah, that will come, because that will you'll have to go before the competent court or the relevant court, not here.
Non-compoundable offences.
But that would come by way of there will be a fresh proceedings then.
Yes, my lord. I'll be fine.
Not necessarily.
Yes.
So we'll dispose of this
yes,
anticipatory bill.
Yes.
Fine.
Deeply obliged.
May it please your lordship. Lordship, I beg to mention item number 15 and 16. Yes, I revoke this matter, your lordship. I humbly pray for 1 week time to argue this matter, your lordship.
You are for?
I am for the appellant in this case, your lordship.
On pre-made by the appellant, this is matter of the 3 weeks.
Please, your lordship, I beg to mention item number 14. For further 3 weeks. I need some more time, your lordship, to prepare the matter.
It's a contempt application matter.
It's in Igram's case.
So hardly any contempt matter unnecessary they're delaying it.
You will say that, otherwise they would not have come. If there is no ground, they would not have come.
There's absolutely no ground.
That is your version, not theirs. Fine.
I think that seeking adjournment also indicates that also.
If there is no ground, then they will definitely either withdraw it or you fight it out.
Well, the writ petitions have also been filed.
That's it.
A civil suit has been filed. Contempt has been filed. And the person has already completed his MD, has gone back.
Okay. Once he has completed his MD, he goes back.
My lord, after the intervention of this honorable court, because he could not submit his thesis in time, my lord, of MD, they have to submit a thesis. This honorable court, then matter went up to division bench, up to Supreme Court, my lord. extension was granted, he submitted his thesis, he is passed out, he is cleared, so matter should end there, my lord.
We will look into it then. On pre-meet by the petitioner, let's this matter of the 3 weeks.
Daily costless item number 1.
This is the same matter, my lord, where service is.
So what do? We are stuck in this.
My lord, what I was proposing, my lord, subject to his lordships. First, I've come across 2 decisions of the Supreme Court, my lord, that we can file a fresh complaint before the trial court itself. Now, the first judgment, if lordships kindly see, para 22 to 29, my lord.
Oh, if you wish to file a fresh complaint, that is your prerogative. If
My lordships grant me permission, my lord, and because there's some delay because pendency of this matter, with that much liberty is given, we will withdraw this, my lord, and we will approach the trial court. Well, only that liberty may be given, and some reference to these 2 citations, my lord, it will be easier for us to put trial court also, my lord.
have you given a copy?
First one is para 22 to 29, my lord. Para 26 of the first one, my lord.
So para 26 is the relevant.
My lord, para 23 also, my lord. May I just read para 23?
Yes.
In the
Well, I've
instant
read it. This is only with regard to the
dismissal for default.
dismissal for.
In fact, the Supreme Court has said that even if a complaint is dismissed on merit also, then also if there is sufficient reason for that, it can be done. And when it is dismissed simply for default, always there is a second complaint can be filed. Para 26, if lordships is gone through.
Yes.
And then second judgment, my lord, para 12 and 14.
This was the case referred to in para 26.
Yes, my lord.
Yes.
Para 12, my lord.
Para 12.
If the dismissal of the complaint was not on merit but on default of the complainant to be present, there is no bar in the complainant moving the magistrate again with a second complaint on the same facts. But if the dismissal of the complaint under section 203 of the code was on merits, the position would be different. There appeared a difference of opinion earlier as to whether a second complaint could have been filed when the dismissal was under section 203. The controversy was settled by this court in Pramatat Nath Talukdar versus so-and-so. A majority of the judges of the 3 judges bench held thus. An order of dismissal under section 203 CRPC is, however, no bar to the entertainment of a second complaint on the same facts, but it will be entertained only in exceptional circumstances That is, where the previous order is passed on an incomplete record or on a misunderstanding of the nature of the complaint, or it was manifestly absurd, unjust, or foolish, or where new facts which could not, with reasonable diligence, have been brought on the record in the previous proceedings have been adduced. It cannot be said to be in the interest of justice that after a decision has been given against the complaint, upon a full consideration of the case, he or any other person should be given another opportunity to have his complaint inquired there. So 203 dismissal is, my lord, after examining the complainant, my lord,
Yes.
on merit. Then para 14, my lord, as the magistrate did not consider the materials on record when he dismissed the first complaint, instead the said course was adopted by him only as a consequence of the default of the complainant presenting herself when the case was called. There is no reason to shut the door before her once and for all. The High Court has correctly interpreted with the order of the Sessions Court by restoring the complaint, and the proceedings initiated thereon will therefore dismiss the appeal.
Yes.
Your Lordship, if they want to file also second complaint, fresh complaint, they can withdraw this matter. So they can give
Yes, that's what-
submission before
that is what
the
has been
court
submitted.
below.
That is what has been submitted.
Your Honor, my humble submission is no observation may be given in this judgment, Your Honor, because they can withdraw directly and file there, and they can give submission and they can satisfy the court below, Your Honor, if the fresh complaint can be entertained on.
My lord, this should not come from the mouth of respondent number 3, my lord. Respondent number 3 is represented. She is pleading on behalf of others. I do not know.
I am appearing for respondent number 3, so I am giving my
But
submission.
respondent
Lord,
number 3, even in the trial court, you are there.
Yes.
Yes. So this plea cannot be taken by respondent number 3, my lord.
It may not be taken. But as to the issue of law, it can always be pointed
I am
out.
not taking because qua respondent number 3, your lordship can even restore it now because they are represented, my lord. Other respondents, because they are not represented, my lord, that is why we are in the
Yes,
stalemate
that
situation.
of course.
With your Lordship, we have given a submit judgment where it has said, like, if the other accused are not present, joint trial order is there, so only one accused cannot be taken of the matter for one accused. Your Lordship. It should be joint trial.
That is submission on the merit of the situation as far as the impugned order is concerned. But at this point of time, the petitioner would like to withdraw
Yes, they can
petition
withdraw.
with liberty to file a fresh complaint. As and when the complaint is filed, if you are aggrieved and if notice is issued to you, because fresh notice will be issued upon you also, then you can make your opposition then.
But my only humble submission, no observation may be given on this judgment.
But these
They can withdraw with the liberty as they have.
the apex court judgment are here. See, this court has been led to this judgment which says otherwise.
But your Lordship, they have failed to take steps also to call the other respondents, your Lordship.
Well, that is
We've taken steps of almost
incidental to the incidental to the process or the proceedings. So would you like to make a submission here? Would you like to oppose the prayer made?
Yes, your Lordship. So some time may be given.
You go through their judgment.
At least 1 week, your Lordship. Can I get the copy?
On pre-made by the parties. This is matter after 1 week.
Item number 3.
Yes, who's appearing?
Lordship, I'm appearing for the state.
You're appearing for both the respondents.
Lordship. Both the response, Lordship.
None appears for the petitioner. Accordingly, this matter is adjourned, let's say after 1 week, 2 weeks.
Lordship, Lodge.
Item number 4.
I'm entering appearance on behalf of respondent number 7, my lord, in this case.
Lordship, last occasion I was supposed to produce instructions. It so happened there was a change in dispensation in the district council. I was unable to get any instruction whatsoever. I just need a very short time, Your Lordship, as to what transpired with that inquiry, which was before the inquiry officer against the respondent number 6. I just need some time because a new executive committee has come into place.
The petitioner has pressed for disposal of that inquiry.
My lord, that is definitely it is there, but then that is we are primarily on the, my lord, acceptance of resignation of respondent number 6, and my lord, thereafter holding of election. We are challenging the very legality of the election.
Because there are 3 aspects to the matter. Firstly is the suspension of the then CM, an inquiry conducted against him.
But inquiry is pending, of course. Right now, my lord, we have
Inquiry
not
is pending, yes. Thereafter,
there are 2 issues.
in the meantime, he has resigned.
Yes, my lord.
And then subsequently, a new CM was elected.
Yes.
So
They are the main. These are the main.
all these
resignation and the new.
all these 3 form a chain or the.
My lord, my lord.
I don't know whether this honorable court will be able to allow the prayer of my learned senior, because this is the prayer which they have sought to impugn order is 29/11/2023, my lord. So we are only in the month of June. We're not in
Question of
July.
illegality doesn't matter, my lord. Lapse of time will not make.
Not lots of time. We are ahead of the time. 29/11/2023. 29/11.
This will be
My lord, both in the writ petition as well as in the miscase, my lord. Whether this honorable court, my lord, will.
My lord, document will speak for itself, my lord, definitely.
No, but my lord, we'll have to go as per the prayer.
So this can be corrected, my lord. We'll correct it.
I'm just pointing out to the court, my lord.
I'm thankful to my learned friend.
This morning I came across, Your Lordship, of a Supreme Court decision, anti-FIR. An FIR which was filed even before the occurrence.
Yes, I called it.
3/9/2023 and
Page.
impugn order, my lord. Page 33 of the writ petition, my lord. The prayer, my lord.
Oh yes.
My lord, page 33, letter dated 10/11/2023, my lord.
10/11/2023.
And my lord will see the next page, my lord. Page 34.
Same mistake.
3/9, my lord. 2 impugn order, my lord. 3/9/2023, my lord. So, my lord, I think for us also it will be difficult to file any.
These documents, relevant documents are annexed, my lord.
That is
So there will be
true.
difficulty. And my lord, I may be allowed to correct it, my lord.
You have to be careful.
My lord, I'm sorry, my lord. It's my apology for that.
So all the respondents are
I think
represented.
I'm appearing for.
Oh no.
Who is appearing for 6?
6 we don't know whether notice has been.
Notice?
Notice, my lord, the postal website says it has been sought, but then ID card has not come, my lord.
Oh, we are waiting
To wait for the.
Then you have to wait.
But if it doesn't come, we'll file an affidavit to bring in.
Yes, of course.
That has been.
So what we'll do is at this point of time, we'll wait for the service report on 6. In the meantime, if you want to file an affidavit, you file.
They'll have to make necessary correction also, my lord.
Let them correct first.
Without correction.
Let them do the correction first. And
My correction is will not be a big thing, my lord. It's only a date, madam. That has to be changed, so we'll correct it.
Heard Mr. B. Sati, learned senior counsel, appearing for the petitioner. At the outset, it was pointed out that there are some typographical error in the body of the petition,
And the prayer.
particularly at the prayer portion, wherein at page
33, madam.
33 of this petition, the date 10/11/2023 appears, which ought to have been 10/11/2022. And also at page 34, where is it?
My lord, the last but third line of the first paragraph, my lord.
The last, the
3923, my lord.
the last but 3 lines of the first paragraph, where the figures, the date 3/9/2023 appears, which also ought to have been 3/9/2022. That senior counsel has submitted that may be allowed to correct such error. Seems allowed. As far as the process is concerned, it is submitted that the notice on respondent, served on respondent, issued upon respondent 6 have not been confirmed, and to this effect and to this extent, the learned senior counsel has submitted that on confirmation, affidavit of service may be allowed to be filed. As far as the other respondents are concerned, that is respondent 1, 2, 3 and 4, 1, 2, 3, 4 and 5, Mr. B.J.K. Kanta, learned senior counsel, who is also the special counsel for the respondent KHADC, has submitted that he may be allowed to file an affidavit in opposition in this regard. Similarly, Mr. L. Karim, learned counsel for the respondent number 7, has submitted that he also may be allowed to file an affidavit in opposition. On pre-made, the same is allowed. List this matter to 2 weeks.
There is an interim petition.
It's too late.
Petition for interim. No, well, whether they will file a shockers or not, that is the main thing.
The Lordship, we just want 3 weeks time.
Pre-made?
My lord, we are seeking stay of the acceptance of resignation as well as the result of the election.
The election has already been concluded. I have
Well,
already taken
if my
office.
petition is rejected, there is no problem. But since I have filed a thing, it must be come to a logical conclusion. That should be hard.
We'll file a response to that also, Your Lordship. We want 3 weeks time, Your Lordship, because
In any case, though, see, if all the parties have filed their affidavit in opposition, then the matter can be heard finally. Where's the
desire 3 weeks time, Your Lordship.
3 weeks?
Yes, Your Lordship.
Too long, my lord.
Because the change in governor yet to clear the executive committee thing also.
That's I know 3 weeks though. Can I give this case? The counsel for the respondents 1, 2, 5, as well as respondent number 6, number 7, has prayed for some time to file the response to the application made with a prayer for interim relief. On pre-made, the same is allowed. Let the same be filed within the next date fix. List the matter up to 3 weeks.
Much obliged.
Item number 5.
This is that matter.
My lord, kindly have this matter at the end of the board. My colleague is unable to join yet.
So end of the board.
Item number 6.
Lordship, in this matter, the respondents are to come with instructions.
No, my lord, there is nothing to bring anything on.
I think last time Mr.
instructions.
Sengupta has stated that nothing is
We are ready for
nothing is
hearing, my
forthcoming from their side.
Lordship, at the start of the hearing,
Mr. Pauly started with the hearing. Then after that, the state respondents, they stated that there's no rules. So for that, they have to bring forward some document saying that
My
there's no
lord,
rules.
the main grievance of the writ petition started is that by the removing of the hoardings, my lord. So against that they have filed this writ petition, and our stand is that we have started removing the hoardings on the directions of the Supreme Court order, my lord. So that is our limited stance, my lord. Beyond this, we are not required to answer anything more or less, my lord. So
that has to be determined is, my lord, the Supreme Court judgment has to be distinguished.
Distinguished.
Whether it applies to only liquor hoardings or all.
And also as far as the location is concerned, whether it applies only on the national highway or the district roads or whatever.
Because we have not gone to the Supreme Court for clarification, neither the writ petitioners, my lord. But what we understood, we had complied.
The onus is on you. The onus is on you. You are the authority.
My lord, we are also, in order to avoid any kind of contempt, my lord, we have taken up promptly and we are doing to the best of our ability, to the best of our understanding.
But in the meantime, it is incumbent upon you to, at least bring out some sort of rules, some sort of policy, regulation. This matter has been there for since 2004.
That is for the legislatures to.
No, it's not for the legislature. It's for your. It would depend on your advice, sir.
True, my lord. And
you are a responsible officer of the state.
Correct, my lord. But then, what is not there, it may take time or not. I cannot make any commitment on to that extent, my lord. But whatever facts are before this court, my lord, we have already filed our counter affidavit, my lord. Our stands are there. If our stands are wrong, then it will be subject to adjudication, my lord. So,
Your Lordship, there's another Supreme Court judgment also, which has exempted the state and state of Sikkim with regard to the area, topographical area.
And that is only with regard to the liquor hoardings, if I'm not mistaken. But here, you see, the case here is with regard to all
the hoardings.
Every kind of hoardings, advertisement, whatever. So we'll hear the matter on merits. We start.
Your Lordship, then let it come at the end of the board.
Next week, my lord.
Lordship, end of the board, Lordship. Mr. Pauly is stuck in traffic. Will be.
No, my lord. Next week, in that case, we are.
Why?
My lord, when the matter is called and the learned counsel is not there and others, it is.
Lordship, next week is.
There is no such urgency, also, my lord, as such. Next week will be better.
On pre-made by the respondent, this is matter of 1 week.
Your Lordship, I'm praying after 2 weeks because next week, Mr. Paul, you won't be available.
2 weeks. But definitely we'll finish it off.
We'll finish it either this side or that side, my lord.
Item number 7.
My lord, this matter, Mr. Barua is still on sanction leave. As informed on the last occasion, he is attending his sick mother. So my lord, he has given me a call also this morning that he will not be in a position to be before the court, my lord.
On pre-made, it is submitted at the bar that the learned counsel for the petitioner is indisposed on ground of personal difficulty. Accordingly, this matter could not be taken up today. List the same after 2 weeks.
Item number 9.
Lord, in this matter, Mr. Paul is appearing for MPSC, and MPSC is the main party, my lord. So I don't know in his absence whether we can.
What do we do?
My lord, since Mr. Paul is not here, we can have this matter after a week.
2 weeks then.
2 weeks.
On pre-made by the parties, list this matter after 2 weeks.
Item number 10.
Yes, what is the case about?
Lordship, before I start, the entire matter, Your Lordship, the entire argument will be based on three major points, Your Lordship. That is, point number one is non-compliance of the statutory provisions of the Assam Rifle Act, Your Lordship. The second is the biasness that was there during the proceeding of the General Assam Rifle Code. And the third one will be the violation of principles of natural justice, which was grossly violated, Your Lordship, during the course of the entire trial proceeding, which was initiated against the petitioner in this case, Your Lordship. So if I may just briefly submit the brief facts of the case, Your Lordship. The petitioner herein was enrolled and appointed in the Assam Rifle on 10th of June 2006, Your Lordship.
Enrolled on
10th of June 2006, Your Lordship. Your Lordship, if I may take Your Lordship to Annexure 1, page 38, Your Lordship.
Page
38, Your Lordship. Yes, Your Lordship. The entire his date of enrollment and appointment is given as 10th June 2005, Your Lordship. Sorry, I stand rectified, Your Lordship. 10th June 2005, Your Lordship. And his total length of service, Your Lordship, till his dismissal from the service was 18 years, 8 months and 2 days, Your Lordship. So, Your Lordship, after serving for almost 18 years, 8 months and 2 days, the petitioner was dismissed from service on being convicted by the General Assam Rifle Court Martial, Your Lordship, which was the proceeding which was initiated against the petitioner on the strength of a complaint which was filed by one of the superior officer against the petitioner, Your Lordship, alleging that during the absence of the officer, the petitioner has molested the wife of the senior officer. Your Lordship, the petitioner, ever since his enrollment in the Assam Rifle as a rifleman GD, Your Lordship, he has been performing his duties to the utter satisfaction of the units that he has been ever attached to, Your Lordship. And Your Lordship, the petitioner, during the course of his service tenure, Your Lordship, he was never reprimanded. There was no reading entry ever been marked in his service records, Your Lordship. Your Lordship, the petitioner was posted at Assam Rifle Signal Unit, Happy Valley, Shillong, on extra regimental employment since 26/10/2019, Your Lordship. Initially, he was posted in some other units, Your Lordship. So he was called to perform extra regimental employment at Shillong in Assam Rifle Administrative Support Unit, Your Lordship. So as soon as he joined on 26/10/2019 on his extra regimental employment, he was initially performing general duty about 10 to 15 days, Your Lordship, and after which the petitioner was attached as buddy or helper, we can say that, Your Lordship, to one of the 2IC officer for about 1 month, Your Lordship, and after which the petitioner was attached as a buddy to the complainant, who being the senior officer in the instant case, Your Lordship. From the month of December 2019, Your Lordship, he was attached with the complainant as a buddy. So, Your Lordship, the petitioner in the month of somewhere in the month of January 2020 went for a casual leave, and after his returning back from his leave, Your Lordship, the petitioner was again asked to join as a buddy duty with the said complainant only, Your Lordship, because the complainant was so satisfied with his performance of his duty that he again recalled him to be attached as buddy with him only, Your Lordship. So, Your Lordship, after coming back from the leave also, Your Lordship, then he again rejoined with the same officers, Your Lordship. So, Your Lordship, before I proceed any further, Your Lordship, I would like to bring before Your Lordship the duties that has to be performed by buddy. Buddy as a helper to the senior officer, Your Lordship. They are often called as Sahayak also. So, Your Lordship, the buddy is a practice of utilizing the services of the armed force personnel lower in rank to serve as a buddy or Sahayak to the officer as a helper to do their minimal works, such as preparing the uniforms, collecting ration, and taking care of other day-to-day activities of the officers, Your Lordship. The said practice of misutilizing the armed forces personnel who are trained to defend the country, Your Lordship, by the superior officer in the Indian Army or the paramilitary force, such as Assam Rifles, are adopted from a colonial era since British times, Your Lordship. This buddy, Your Lordship, who often they are misutilized with their services by the senior officers, Your Lordship, who are trained as an armed force personnel, Your Lordship, are engaged by the senior officer.
So the extent of their duties
yes.
as buddy.
Yes, Your Lordship.
Is it under some regulation or something?
No, Your Lordship. That's what, Your Lordship. There are no such regulations which stipulates the duties that has to be performed by the buddies, Your Lordship. If I may take Your Lordship to
so can you define?
Yes. I'll just.
What does it mean by general duty?
General duty.
What does general duty
Your
mean?
Lordship, the general duties are
usually they are enrolled as riflemen.
Yes, Your Lordship.
GD or
Yes, Your Lordship.
so on and so forth. How you define that?
Your Lordship, what happens is this: general duty comes under, like, even the clerks and all. They are also sometimes they fall under general duty only. But those armed forces personnel who are specially trained with arms and all, Your Lordship, during the course of their employment, such as in this case, the petitioner has been called for extra regimental employment, Your Lordship, and he has been engaged as buddy, Your Lordship. Although he has been trained in arms and all, but still, Your Lordship, the scope of I would say the scope of general duty and duty performed by them are wide, Your Lordship. So within that parameter only, Your Lordship, he has been attached as a buddy. So,
but there must be some definition. There must be some.
I'll just come to that, Your Lordship. There is one. If I may come to Annexure 3, Your Lordship, page 40. The relevant page would be, Your Lordship, page 50, Your Lordship, the relevant page. Your Lordship, it's a Standing Committee on Defence, 15th Lok Sabha, Ministry of Defence. It's a report that was prepared by Ministry of Defence, Your Lordship. So, Your Lordship, the relevant para, I'll just go through those relevant para, page 50, Your Lordship. Para number 10, Your Lordship. Those are the recommendation that was put forward by the Ministry of Defence, Your Lordship. The committee understands that the practice of utilizing services of Jawan as Sahayaks is prevalent in the army in one form or other since British days. It is learned that numerous Jawans are engaged at the residence of some of the senior officers for domestic work and to serve the family members of officers, Your Lordship. A representative of the army categorically deposed before the committee that the Jawans are not technically supposed to attend to the household duties at the residence, Your Lordship. This is very much important in this case, Your Lordship. A representative of the army categorically deposed before the committee that the Jawans are not technically supposed to attend to the household duties at the residence of the officer, and the personnel attending to such duties do so due to their reverence, Your Lordship. The committee hardly need to stress that Jawans are recruited for serving the nation and not to serve the family members of the officer in household work which is demeaning and humiliating, Your Lordship. The committee take a very serious view of the shameful practice which should have no place in the independent India. The committee expect the Ministry of Defence to issue instruction to stop the practice forthwith, as this lowers the self-esteem of Jawan, Your Lordship. Any officer found to be violating the instruction in this regard should be dealt with severely. Similar action needs to be taken by the Ministry of Home Affairs in respect of paramilitary organization and other organization. So Assam Rifle falls under paramilitary organization only, Your Lordship. Then page 51, Your Lordship. May I read, Your Lordship? Exhaustive instructions regarding appropriate employment of Sahayaks and Buddy are same, Your Lordship.
Yes.
Have been issued from time to time by Army Headquarters. Comprehensive instructions have been issued to the environment, while letter number so and so, highlighting the following aspects. Sahayak is a comrade in arms to officer JCO, symbolizing trust, respect, warmth, confidence and interdependence, which are the fundamentals of relations between the leaders and the led. Sahayak is a soldier who, in addition to his duty, provides the essential support to authorized officer and JCOs, both in peace and war, to enable them to fully attend to their assigned duty. He also provides leaders a direct contact with men and thus enables officers and JCOs to gain an insight into the state of morale and being of men. Sahayak will be attached to regular army units and provided proper living accommodation and messing facilities. The officers to whom Sahayaks are provided will ensure such facilities are arranged. Sahayaks will not be employed for menial household work. This will also be very important in our case here.
Yes.
It has also been stressed that there is an urgent and continuous need to impress upon all concerned that Sahayaks, being combatant soldiers, under no circumstances are to be employed on a job which is not in conformity with the dignity and self-respect of a soldier, Your Lordship. In my case also, Your Lordship, the petitioner's dignity and self-respect was compromised, Your Lordship. Therefore, it is the duty of all officers, JCO and commander in the chain to ensure that strict checks are instituted to prevent misuse of Sahayaks, and that any violation of existing instructions and guidelines should be dealt with immediately. So time and again, Your Lordship, these instructions have come from Ministry of Defence, Ministry of Home Affairs, but no heeds were given to those instructions, Your Lordship.
This has come in the form of a advisory.
Yes, Your Lordship. Advisory, and failing which, Your Lordship, the necessary action may be taken against those officers who are not.
But under which provision?
Your Lordship, this committee reports only, it says.
It must have statutory power.
Yes, Your Lordship.
Yes, please go.
In my case, Your Lordship, the officer who being the complainant had initially during his tenure of the service had personal cook when he was initially transferred to Assam Rifle on deputation, Your Lordship. He came with his personal cook and he kept a maid servant also to do those household menial work. But during the first phase of the lockdown, of COVID-19 lockdown, Your Lordship, what has happened that the cook, he left his job, he returned back to his hometown, Your Lordship, and the lady, the helper who was coming, she could not come because her house was declared under some containment zone, Your Lordship. So even ultimately she left. Then during the course of his employment, the petitioner, he used to go to the officer's residence at early morning, prepare his uniforms, prepare his everything, get ready for the officers to leave for his office. And once he leaves, Your Lordship, the petitioner used to stay back at his residence, helping the officer's wife in other activities of the house, Your Lordship. So during the course, after this, both the servants left, the wife of the officer, she started giving an examples to the petitioner, stating that since you being a buddy, you are supposed to help me with the household work as well, your lordship. So she cited examples of other buddy as well who were doing those menial household work, as in like cleaning the house, cleaning utensils, to the extent of cleaning clothes also, your lordship. So initially, your lordship, the petitioner did not give any heed to it. But in a day or two, your lordship, what has happened? The complainant wife, the officer wife, she started asking the petitioner to do those activities only, your lordship, because she was helpless. She couldn't do other household work, your lordship. So for that reason, she started asking the petitioner that you do these activities as well, and it is your duty, and you are bound to do those household work as well. To which, your lordship, the petitioner refused to do, your lordship, because his dignity was compromised, your lordship. He, being a armed force member, he is not supposed to do those household activities, your lordship. So the refusal on the part of the petitioner has led the complainant, the officer, to make the entire concocted stories that in the absence of the officer at his residence, your lordship, the petitioner tried to molest the wife of the officer, your lordship, which is utterly false, your lordship. Because why I would say, your lordship, the petitioner was serving with the said officer for almost 2 years, your lordship. During that period also, your lordship, the officer would leave his residence at the early morning around 9 o'clock, and he returns back to his residence by 4-5. During those period of time, your lordship, the petitioner would be there helping the other worker of the residence to do the work, to carry ration, to bring ration to his residence, and everything, your lordship. So, your lordship, all those 2 years also, your lordship, in between that also, your lordship, whenever the complainant, the officer, would leave the station, your lordship, he would hand over the keys of the residence to the petitioner also, your lordship. He had so much of faith in him that, your lordship, he would hand over the keys of the residence to the petitioner so that he could look after the residence in his absence, and before he returns back from his leave, he would do the dusting and everything. So, your lordship, the trust was that much, your lordship. So all these 2 years, your lordship, there was no such incident which was reported against the accused person, your lordship, or the petitioner, your lordship. It was only reported, your lordship, once the petitioner, he refused to do those minimal household work, your lordship. Once he refused that, the officer concerned, because on the day he refused to do that household work, your lordship, immediately the petitioner, he went back to his immediate senior and reported the same, your lordship, saying that since I have been asked to do such kind of minimal household work which I'm not authorized to do at all, so kindly take care of my complaint. His immediate senior, what he does, your lordship, he takes the petitioner to the adjutant. The commandant was on leave on that particular day, your lordship, so he takes the petitioner to adjutant. Then before adjutant also, he goes and he narrates that same story, your lordship, the petitioner, saying that in the absence of the officer, the wife of the officer, she asked me to do those minimal household work, which I refused, and I came back and I'm reporting to you. In the evening, your lordship, when the officer returns and he realizes that the petitioner has gone to the office concerned and his immediate senior were reported about the incident which has taken place at his residence, your lordship, the officer comes back to his residence and he immediately calls the petitioner to his residence, your lordship. After receiving the call from the officer, the petitioner immediately goes to the officer residence and he reports him, saying that, sir, this things has happened. But your lordship, instead of taking a lenient view, your lordship, the officer concerned, he started threatening the petitioner with dire consequences, your lordship. He said that I will take necessary action against you, to the extent that I may even take your family away from this place. Such were the threatening that was put on petitioner, your lordship. Then, your lordship, what happens? The petitioner returns back to his quarter. The next morning, the commandant of the unit, he comes. The commandant is reported about the same, your lordship. The commandant calls for a meeting between the officer, the wife, and the petitioner to his residence, your lordship. Before the petitioner, he goes and appears before the said meeting, which was convened by the commandant, and that meeting was convened unofficially, your lordship, because the officer, he wanted that the petitioner should come and seek apologies, and he should withdraw all the complaint that has been narrated before the commandant, your lordship. So the next day he meets the entire thing, your lordship. In spite of that, your lordship, then the complaint was filed. Court of inquiry was initiated against the accused person, your lordship. During the course of the court of inquiry also, your lordship, the petitioner agitated before the concerned officer, stating that the court of inquiry was conducted in an English language, which the petitioner was not so well versed with, your lordship. And he wanted that the entire court of inquiry proceeding was supposed to be held in Hindi, so that at least he could communicate with the witness also. That was also never done.
Was he allowed to have a defense counsel or
during
next,
the course
next
of,
friend?
No, your lordship. During the course of court of inquiry, that is not as such not provided. But during the course of the trial of General Assam Rifle Court, a defense counsel was provided, your lordship. He himself, he has engaged a defense counsel before. So, your lordship, if I may take your lordship to the convening order, your lordship, since the convening order is supposed to be convened by the Director General or the Assam Rifle as per the provision of section 87 of the Assam Rifle Act, your lordship. As per section 87, your lordship, it states that the convening order for General Assam Rifle Court, it has to be convened either by the central government,
yes,
or by the DG, Director General, or if any other officer convenes that General Assam Rifle Court Martial proceeding, then that has to be based on the warrant that has been issued on behalf of the concerned officer for calling that particular proceeding, your lordship. In our case, what has happened, your lordship? No such warrant was issued against the convening officer. The convening officer, who is the, your lordship, I'll just he's additional Director General, your lordship. He's not the Director General. So he should have had a warrant before he called or before he convened that particular proceeding.
He was not the competent
yes, your
authority.
lordship. He was not the competent authority to convene that particular order.
Okay.
Or if he would have at all got the warrant from
He
the
should have
DG,
got the warrant.
yes, your lordship.
Which
is not in my case, your lordship. So the entire proceeding, the convening order was done in haste manner, your lordship. With the sole motive, your lordship, to prosecute the petitioner and dismiss the petitioner from service, your lordship. So section 87 of the Assam Rifle Act was not at all complied with, your lordship, which is one of the statutory provisions of the as per the Assam Rifle Act, Your Lordship. So if at all the convening order itself is not convened properly and due provisions, statutory provisions were not followed, Your Lordship, the entire proceeding is vitiated, Your Lordship. My second point of argument is that, Your Lordship, the entire officer, right from presiding officer to the other officer who were proceeding the court-martial proceeding, Your Lordship, among them, the presiding officer was totally biased against the accused, the petitioner in this case. Why I'll bring, Your Lordship, the chain of
Yes.
entire composition of the Assam Rifle Courts, Your Lordship. I'll just bring on record that. Your Lordship, serial number 1 is the presiding officer, who is Colonel Vikash Singh. He is from General Staff Branch, Your Lordship.
Okay.
Same formation and same location, DGR, Laikor, Shillong. Then, Your Lordship, the convening order, Your Lordship, the next page, Your Lordship, in the same table, Your Lordship, the convening order was passed by Brigadier Tapan Lal Shah, officiating Additional Director General, Assam Rifle, Your Lordship. He is also from same branch, that is GS branch. Then on third, Your Lordship, the complainant, Your Lordship, last para, Lieutenant Colonel Abhimanyu, who is the husband of the, Your Lordship, the complainant. He is from same branch, Your Lordship, GS branch. The hierarchy is as such that, Your Lordship, the chain of command is the same, Your Lordship. The presiding officer reports to the GS branch headed by Brigadier Tapan Lal Shah, who has convened the entire General Assam Rifle Court proceeding, Your Lordship. The complainant also, he has come from same branch. The presiding officer, he has also come from the same branch. And the officer convening this Assam Rifle Court Martial proceeding, Your Lordship, he has also come from the same branch, Your Lordship.
So that should not have been the norm.
Not at all, Your Lordship. Not at all.
Is it indicated anywhere?
Yes, 106.
Yes.
My next point of argument is that, Your Lordship,
You were saying something about the norm.
about 106, Your Lordship.
What does 106 is?
There are certain catena of judgments, Your Lordship, which the Honorable Supreme Court also has stated that the convening authority and the officer presiding with the court-martial proceeding should not be from the same branch or from the same unit as well, Your Lordship. Okay. Not from the same unit. I'll place those judgments also, Your Lordship.
Fine.
My third leg of argument is that, Your Lordship, there was a gross violation of principle of natural justice, Your Lordship.
Yes.
Which is one of the basic principle for every criminal proceeding, Your Lordship. After the prosecution witness, Your Lordship, almost 7 prosecution witnesses were brought, Your Lordship, by the respondent authority. After examination and cross-examination of those 7 witnesses, the defense was asked to bring his defense witnesses, Your Lordship. Accordingly, Your Lordship, the defense counsel has submitted a list of defense witnesses numbering 10 in numbers, Your Lordship, who would come and depose before the General Assam Rifle Court Martial. Among those, Your Lordship, there were almost 3 to 4 vital witnesses which were to be brought in defense of the petitioner, Your Lordship. After submitting that list of witnesses, Your Lordship, the presiding officer, in connivance with the law officer, Your Lordship, rejected all those 10 numbers of witnesses, defense witnesses, and those defense witnesses were not at all allowed to be brought before the Assam Rifle Court proceedings, Your Lordship. So, Your Lordship, naturally, Your Lordship, if I had to bring my defense witnesses, Your Lordship, the witnesses will come and depose before the court. His role, his defense, his whatever statement he has got, Your Lordship. And those list of defense witnesses also not private witnesses, Your Lordship. Those were from Assam Rifle only, Your Lordship. Some of them were commandant of the petitioner also, Your Lordship. So none of those witnesses were allowed to be examined, Your Lordship, in his defense. Rather, Your Lordship, the respondent authority rejected all the 8 witnesses and only allowed 2 witnesses to be examined as a defense witnesses, Your Lordship. And among those 2 witnesses also, Your Lordship, one witness was dropped by the prosecution, that was allowed, and the other witness, who being the wife of the petitioner, she was allowed. So the petitioner was also not allowed to bring witnesses on his behalf, Your Lordship. So it clearly shows that, Your Lordship, the entire proceeding was biased. There was gross violation of principles of natural justice, Your Lordship. The convening order was not passed properly, Your Lordship, without having any authority. If the convening order itself has been passed without having any authority, Your Lordship, the entire trial and the entire proceeding goes because it has been vitiated, because that authority itself has no power to call for that. Your Lordship, I'll 66. Yes, Your Lordship. If your Lordship may kindly Rule 66.
Rule 66.
Rule 66 of what?
66.
Assam Rifle rules, Assam Rifle regulations, Your Lordship.
Assam Rifle rules or regulations?
Rules.
Yes.
This one.
Okay. Rule 66, Your Lordship. Composition of General and Petty Assam Rifle Courts, Your Lordship. A court shall consist, as far as practicable, of officers of different battalions or units, Your Lordship. The members of a court for the trial of an officer shall be of a rank not lower than the rank of that officer, unless in the opinion of the convening officer of such rank are not having due regard to the exigencies of the public service available, and such opinions shall be recorded in the convening order. We are just concerned with the first part only, Your Lordship. A court shall consist, as far as applicable, of officers of different battalions of units, Your Lordship. And in our case, Your Lordship, the convening order from same branch, the presiding officer from same branch, and the complainant officer also from same branch, Your Lordship. Your Lordship, I'll file my compilation of those judgment, Your Lordship, covering this non-compliance of statutory provisions and the violation of those principles.
done?
Yes, Your Lordship.
File a written
Yes,
argument. And
yes, Your Lordship. I'll file
cite
that.
all your
written-
authorities.
Yes, Your Lordship.
Yes, Dr. Mosiga.
My lord, it appears that the writ petitions which they filed, they have not annexed any of the documents, my lord. Even the impugned judgment is not annexed with this.
Impugned judgment?
Your Lordship, initially I had made a prayer before the Honorable Court to call for the entire
But the records are here with me.
proceedings.
But it is very bulky, my lord.
We can give one copy. Sir, we have brought one copy. If you allow, we can give it.
But
Only
these are the records of the proceedings.
yes, Your Lordship.
Yes.
The entire proceedings.
You have not referred to, I mean, it is not on record.
Some of the annexes are not there, Your Lordship. So I have to.
You could have done that by way of an additional affidavit, extract whatever is required.
Yes, Your
Now you only heard the matter.
That's what I was
Your
thinking,
Lordship
but
would
that
appreciate-
without referring to any of the documents,
Your Lordship-
all verbal submissions have been made, my lord.
Your Lordship, if I may pray, Your Lordship, if the Honorable Court may kindly call the entire case record from the Assam, from the respondent authority, it would be much better.
The
Your
records
Lordship.
are here.
The proceedings
But
of the
you see, you have to stand. You see, your case has to stand on your own feet.
yes, Your Lordship.
If any material that is with you,
Yes.
you have to be relied upon. You have to rely on those. And for that to bring on record, you have to do it by the formal process.
I only have the original records, my lord. Either I make a copy or they can supply a copy, because I'll point out certain orders and documents, my lord.
I'll supply then. In that
All
case, Your
submissions without reference to any document, my lord.
Lordship. I'll supply those.
How do you do it? You do it by way of an
Yes, Your
affidavit then?
Yes, Your Lordship.
You should have done that before you commence
Yes, Your Lordship.
your hearing.
In the meantime, I'll prepare written statement of all those my arguments.
How do you do? I think we'll have to hear the matter again.
Yes, Your Lordship.
Because since if you bring
Yes, Your
additional documents
Yes.
and you have to rely on them,
Yes.
you have to give them a copy and so that they can.
I'll make a copy of the entire
They can
proceedings
refute
and then
whatever allegation you make.
yes, Your Lordship. I'll make a copy of the entire proceeding and submit.
Counsel, Mr. Counsel for the petitioner. However, in course of hearing, Dr. N. Musika, DSGI, has pointed out that relevant records or documents relied upon by the letter counsel in course of his argument before this court are not on record. To this, the letter counsel for the petitioner has submitted that he will be allowed to make a compilation of all the relevant records available with him and to file and to bring the same on record by way of an additional affidavit. Considering the facts and circumstances of this case, the prayer made is allowed. The learned counsel, the petitioner is directed to file the said additional affidavit with advance copy to the respondent to allow them to respond to the same if so advised. As prayed for, how long?
3 weeks.
As prayed for, this is matter up to 3 weeks.
Much.
Item
You'll take back these records with you?
had informed your lordships that requested your lordships to have the end of the board. This is an old matter, my lord. I would request, my lord, to simplify things. I'll prepare a short list of dates, my lord, which will go up to 1.5 pages or 2 pages, and give the law in relation to my lord, compensation for termination. Whether a temporary employment, my lord, if there's a termination, whether it's simpliciter or whether it's punitive. That judgment, my lord. And then your lordships can. But this way, my lord, we cannot continue.
Exactly.
I'll file my list of dates along with the judgment. They can file theirs, my lord.
But now but I still have to hear the parties.
Yes,
On premier, that I have not record that. You do it on your own.
I will do it.
On premier by the parties, list is met after 2 weeks. 2 weeks will be good enough.
Yes, ma'am.